So right now we're telecasting both on the YouTube as well as on Zoom. We're delighted to go live. Impact of impact of new age technology and the catalyst of the wheels of justice in India. On behalf of RDO and Kirit S. Javali, we welcome all of you for today's webinar. The webinar would focus on key issues that are being debated within the judicial economy of the country today. While there's always been thrust given to innovation and technology, COVID-19 has proved to be a catalyst for judicial reforms.
Okay.
On this panel today, we're joined by the eminent jurist and the leader of reforms in India, Justice A K Sikri, Joint Secretary and the torchbearer of reforms in India, and someone who would go on to play a critical role in shaping the polity in this subject, Shri G R Raghavendar, a leader who's built court systems around the world, and the architect of the Dubai International Financial Center, Mark Beer, the doyen of mediation movement in India, someone who's synonymous for ADR and mediation, the godfather, as some say, Mr. Sriram Panchu, the voice of India at the United Nations Law Commission, Dr. Aniruddha Rajput from Luxembourg. And last, India's heartbeat is the SME sector. We're joined by Mr. Parvesh Ketarpal from the SME sector. And the moderator for today's evening program, Kirit S. Javali, a barrister and a practicing Supreme Court advocate. Over to you, Kirit, and welcome all of you.
Thank you. Good evening, everybody. We start this very important webinar. I'd just like to briefly talk for 2 minutes on the background of today's webinar. Essentially, as we all know, technology could play a very pivotal role in improving digital access. One can never replace the courts completely via virtual application, but at the same time, innovation and technology, I believe, are two eyes of the law going forward. With them, we will see an evolution of legal solution that will be offered within the industry. It is exactly at the cross-section where we coexist with law, technology, and human interaction that makes legal technology a timely proposition in times of COVID-19 and post-COVID era. A judicial-private partnership seems like the only way the courts can be agile enough to serve the ends of justice and act as catalysts in ensuring just-in-time dispute resolution services along with the courts and tribunals, and that is what the doctor just ordered. There is therefore an opportunity to restart the wheels of justice through teleconferencing, video conferencing, and other appropriate technology. Without much further ado, I will now start questions and direct questions to each of the participants. I'll start with Mr. Justice A K Sikri. Justice Sikri, given your vast experience having served the Indian judiciary right at the top and having noticed that information technology has invaded the legal profession, dispute resolution is one of the most rapidly developing fields of IT usage. For example, emails, online filing, case management websites, video conferencing, etc. How do you see the role of technology playing an important role in reducing the burden of backlog of cases of Indian courts and providing access to justice?
Thank you, Mr. Kirit, and good evening to all of you. I hope that you're staying safe in this pandemic by maintaining the social distance. That is what we are doing today also, this webinar on this virtual platform. The question which Mr. Kirit you have asked, I feel the two facets of this question.
Yes.
One is bringing the judicial reforms, and other is providing access to justice.
That's right.
Coming to the second aspect first, so therefore what role technology has to play in that?
Yes.
Insofar as providing access to justice is concerned, I think this COVID-19 has proved that during COVID-19, the courts are functioning, of course, maybe in a fragmented form, and not on regular basis as it is in normal times. But at the same time, like all other essential services, which cannot be stalled or stopped, like medical services, grocery, and other things, even in a complete lockdown situation. This is what I feel, that the access to justice is also an essential service. And therefore, by no stretch of imagination, we should have a situation where the courts are not functioning. Even during vacation, when the courts are closed, but we have the system of the court which are functioning during vacation, and they hear urgent matters. One or two judges or one or two courts would sit and would hear urgent matters. And apart from that, the COVID-19 situation, because of pandemic, this itself has raised many kinds of disputes which arise out of this COVID-19. We know what is happening insofar as migrant labor is concerned. We know the question of payment of wages, etc. during lockdown period, if they have not gone there, and if the wages are cut or no wages are paid, these issues are arising. RBI has issued the circular, and now I'm talking of business world. RBI issued the circular that no, during this period, no account should be declared NPA. But many issues have arisen out of that, which are urgently have to be taken care of. So apart from the normal other functions, what I'm trying to say is that COVID itself has brought many kinds of disputes before the courts, which have to be adjudicated upon immediately, whether these relate to social justice or these relate to commercial aspects, maybe about the contract enforcement, force majeure clauses, etc., arising out of that, and criminal cases regarding bails, etc. So courts have to function, and and that is what the access to justice is. And it is the technology only which has come to the aid of the courts, and the courts are functioning, at least trying to do whatever they can. Of course, many courts started with only urgent and very, very urgent matters, then went back to urgent matters, included some more kind of matters. And now, as the example of Delhi High Court, that there almost all benches are sitting in Supreme Court also. Now, many benches are sitting and trying to at least dispose of the new filing SLPs, etc., which are filed. So therefore, as far as access to justice during these trying times is concerned, it is the technology, when the virtual hearing can take place due to the aid of technology, that access to justice, as I said, there can't be a better example of
Yes.
Showing that access to justice can be administered or can be achieved through the process of technology. Now, the second aspect is an equally important aspect, if you may
Yes.
say so, which is regarding the judicial reforms. If we go back in last 15, 20 years now almost, in India, there has been computerization of courts, etc. In 13th Finance Commission in 2012-13 had given 5,000 crores to the courts for bringing this technology. And we have been, going ahead with the computerization of the courts for last many years. So it is the e-filing has started in almost all the courts because of this technology, and the court fee, the many payments, etc. The process fee can be paid now. E-payment can be made through that, and pleadings can be filed. Of course, normally they have to be thereafter replaced by the hard copies as well. But then the summons, etc., through WhatsApp or other means of online means, mails, etc., are this is the process because of which many amendments in rules also have been made by various high courts. So therefore, technology has been coming for bringing judicial reforms. Now, your specific question was about the arrears which are pending.
Yes.
I have always been saying that, look, the help of technology has to be taken even in order to reduce the arrears in the court, and because the technology would be very, very, and it is very, very relevant for case management and court management.
That's
And
right.
and it is this case management and court management. It is not occasion where I can say in great details, but I can only point out this much, that many times for bunching of the cases, so similar kind of cases which are filed, and we take up one case and that is decided. Question of law is decided. Suppose one writ petition is filed challenging virus of one particular provision or some notification issued by the customs or by the income tax authorities or any other notification by RBI, and
Yeah.
the case is decided. 100 such cases are still pending in the system because all these cases were not bunched, and all that has changed for last few years. But then the how many cases should be listed, how many cases the courts can take care of, how many cases should be in what particular, say it's a case before the district court, and district court, the cases may be miscellaneous category, the cases may be miscellaneous arguments on miscellaneous application, that category, the case may be evidence category, the cases may be final arguments categories. So how the roster should be managed, appellate courts also, the technology again can play an important role. So therefore, if the technology, but only thing was, which I always say, that look, this technology, it was realized, as I have seen in last 20 years as judge also, that steps have also been taken, but the pace was not that much, which is now we are realizing we should have started at that pace, and we should achieve that pace, because which now we have come to realize that because of now COVID, when there's no there's a social distancing and there can't be physical hearing at present, then there's no other means but to do it. Now, and another thing which has been added is the virtual hearing through video conferencing, and because that's the only means, and even this means can achieve a lot insofar as judicial reforms are concerned, whether it comes to the, and we can come to that later on, because the question for time being is on access to justice and on another
Role of technology.
aspect, as far as tackling the areas except judicial reforms are concerned. My view is that it can go a long way, and for time being, I'll come back again when other questions are asked. But for time being, I say that even if the normalcy returns, we should continue with the experiment as far as virtual hearing through video conferencing are concerned. Like in Delhi High Court, almost more than 10 years ago, e-court started. They started with one court, and I think today there are more than a dozen e-courts. These are paperless courts. How much advantage it has brought, that paperless courts, and how much saving in terms of cost, etc., and even environmental in that sense. We have been protecting the environment also by not unnecessarily using the pages, and the saving those pages, etc. So therefore, technology has its own benefits. Even when the normal time returns, of course, we can't conceive of or conceptualize of the courts on virtual hearing and no physical hearing at all. But then it has to be a hybrid system even in normal times, and we should keep on experimenting with, like I said, in Delhi High Court, 10 to 12 courts are e-courts. Why not in future also there should be few courts which are virtual courts, or where hearing takes place through video conference, for which we can identify which kinds of cases can go ahead, and all this together may bring lots of reforms. That is what I will say.
Right. That's right. Thank you, sir. I'll just now move on to Mr. Raghavendar. Mr. Raghavendar, you represent a very important ministry, law ministry. Judicial reforms is at the heart of the matter. Ease of business enforcement of contracts is an important aspect from the government's perspective. We are given to understand that the government is keen to develop digital courts. What are your thoughts on the impact of technology as an enabler to building a user-friendly justice ecosystem? Where are we headed? Can we have your views, please?
Yeah, thank you very much. And it's an honor always to be in the company of Justice Sikri, whether it is the Engagement Committee or any other platform. First time I'm seeing in this digital platform. I would like to thank Mr. Javli and others for inviting me. And, the major initiative taken by the judiciary and also government of India is to develop the e-courts project. It's a central sector project funded by government. And then it is completely planned and executed by the E-Committee of the Supreme Court. Today, Justice Sikri proudly talking about, the way judiciary using the technology. It all happened in 2005. The committee submitted a report called National Action Plan for Implementation of ICT-enabled courts, and also to make justice delivery system affordable and cost-effective. This was the plan of the E-Committee, and in 2011 to 2015, the E-Court project phase 1 was implemented, and the E-Court project phase 2 started in 2015 and continuing now. It's going to end, and all disruptive changes have been introduced in this. During this COVID pandemic, courts are functioning. And using the virtual hearing, it's happening because 240 court complexes have been enabled with video conferencing facility. That is the most disruption has been done. Even 1,272 jails have been provided with the video conferencing facility. So this kind of infrastructure has been developed all over India in most of the district courts and subordinate courts. And in Pradyumna Bisht case, Supreme Court directed the central government and all the high courts to install CCTVs in district courts. It all started with the Gurgaon district courts, and then most of the districts have a CCTV facility. And then recently Supreme Court gave a directions about introducing live streaming after Sapnil Patil and Indra Jaisingh and Matthew Nadambura filed a PIL, and the guidelines have been framed with the help of Shri K Venugopal, Attorney General, and approved by the Law Minister, and affidavit filed, and the Supreme Court completely approved. And the National Informatics Center of the Ministry of IT has provided infrastructure to make this happen. So with all the available facility and hardware and software, the system could wake up and handle these unprecedented nature of these events, and still it's happening. It's a coincidence that yesterday only we got a letter from my colleague department, the Department for Industries and Internal Trade Promotion. It forwarded a small questionnaire from the World Bank, now which is assessing the work done by under the ease of doing business in Delhi and Mumbai, how these commercial courts have been handled. They were still performed, facing this COVID pandemic. So I'm in the process of collecting data and information from the Registrar Generals of both Delhi and Mumbai High Court. Soon we'll be forwarding this information to the World Bank, how our district, in the district level, the commercial courts handle this the very important incident, but not stopping the courts mental nature, or occasionally they started hearing the cases. And then most of the district courts, it's some surprising data we got last week from 18th to 22nd of this month. We conducted a video conferences with all the high courts, all the registrar generals, their registrar computers and law secretaries were on the board. They were telling us and feeding the data. It's really mind-boggling. The kind of virtual hearing happened in the remote district of the country. We never very encouraging thing happened and unprecedented thing happened. Something, the technology which has been made available, utilized to the 100%. That's what, IT enabled courts working to the maximum happened during this period.
Right.
So this is really unprecedented.
Right. Thank you, sir. Moving on to Mr. Panchu. Mr. Panchu, you've been a leading senior advocate and now much acclaimed mediator. More recently, the Supreme Court requested your services as a mediator in the Ayodhya matter as well. Do you think pre-court dispute resolution processes can aid in reducing the pendency of the courts in India and play a positive role in amicably resolving conflicts? And can technology be an enabler now more than ever?
All right. I said hello to everybody else, but I think Justice Sikri and Mr. Raghavendar, a quick hello, because you came in a little late. Nice to see both of you. So your question really is in two parts. One is, what about pre-court processes of dispute resolution?
That's right.
The second is the use of technology.
That's right.
So let me address the second first, the use of technology in this context. Now, I think one remarkable thing, can you all hear me? Can you hear me well? Hello?
Yes, we can.
I can't see myself. I think one remarkable thing is that the justice system, the standard adversarial litigation justice system, has survived all these hundreds of years. It survived revolution, the industrial revolution, the information revolution, the internet revolution, standing firm like the Rock of Gibraltar. But this one bug has, I think, brought the system into difficulties which it has never seen before. Because as much as we praise the merits of online courts, it is really alien to our functioning all along. We are used to open settings. We are used to the public gaze. We are used to numbers in court. And that's dictated certain modes of thought and behavior and advocacy, which is integral to that system. We reserve in camera only for very sensitive matters. Now we are grappling with a situation where proximity spells danger. And we have to reinvent, this whole concept really of public hearings. And that's a huge challenge. But this is exactly where mediation may score. Because mediation is the polar opposite, where a court system has to be open and is adversarial. Mediation is a closed door proceeding, which is consensual and relies exclusively on closed door participation with all the parties and with private sessions with individual parties. Now that really, and it's confidential, that actually lends itself to the use of information technology, to the use of online processes. Let me explain why. First, I think we need to get rid of the concept that optimum means perfection. I think we enter an age and a time where nothing can be perfect. Optimum means, I think, best achievable. I think there's a shift we need to make. Now, what will I miss if I conduct mediations online? I'm going to speak into a box, and my face and my voice will come out through your box, having traveled through the world of internet and Wi-Fi and whatever other dark holes that exist. So I will miss the immediacy, the richness, and the directness of complete contact that's possible when two humans sit together. I'm going to miss that. On the other hand, what is it I gain? It's an efficient way to be in contact and to communicate. I can schedule meetings at any time. People don't have to travel huge distances. There's no need for adjournments. I can speak to one party at one time, another party at another time. I can schedule quick meetings, follow-up meetings. It's very, very convenient. It's also going to be cost-effective because I will save people travel. I may save, the use of building spaces. I will cut down costs. I will have control over the process. I think a good online system will tell me, when I can have a full meeting, when I can put people aside in a separate chat room. I can control all that. Whatever I need to control in a mediation, I can control it online. I can also negate rude and offensive behavior. All I have to do is to switch off that person's microphone. Something which is very difficult actually to do in a closed room session. So practically, I think online will suit mediation very well. There are some cautions, And I will come to that, I think, in a further question. So that is as far as the online aspect is concerned. Now, as far as pre-court, pre-litigation mediation,
Yes.
India took a major step sometime, I think, last year or the year before, when it introduced pre-institution mediation, meaning that before you went to court in a commercial case of the value of anything more than rupees 3 lakhs, you had to compulsorily try mediation. Now that is a huge step. It's a huge step. And for that, you just need to look back, not more than 20 years when mediation first came in. It was an object of curiosity. Then it became part of, the alternate disputes resolution system. Then we thought it'll run parallel to the main system. Then we got in this concept of appropriate dispute resolution, where mediation moved a little up the ladder. But now, what are we telling people? You're telling people that before you enter the formal, entrenched, established litigation system, you must cross the bar of mediation. And that's a huge conceptual and operating change. Right now, the law permits you that where you have an interim relief, you don't need to go through mediation. Soon enough, that may get rectified to say, well, after you finish your interim relief arguments, go back to mediation. But just the concept that you must mediate all commercial cases is simply a breathtaking concept. Which is why I think actually, I think our country takes quantum jumps, sometimes without knowing it. We started off court annex mediation in a small way in 2005. Justice Sikri will remember, we started in Chennai, we started in Delhi, and nobody thought it'll take on this kind of a volume. In fact, I remember we requested the High Court in Chennai to give us some rooms, and we identified 2 rooms. Then the building committee was, can we spare these rooms? What? And one judge, I remember, said, give them these 2 rooms. What does it matter? This is not going to last beyond 6 months. I still remember that.
Right.
So it's just taken a quantum jump. Now you look at, pre-institution mediation. Frankly, I don't think anybody really assessed the whole thing. My own guess is that somebody in the, I think the PMO said, we have to improve our global rankings on the ease of doing business. One way is to make litigation, alternative litigation better, enforcement of contracts. And somebody had this bright idea of, mediation before litigation. But it's a huge quantum jump. Hardly any country the world over has done it, except Italy. So India is a real trendsetter as far as is concerned. So when I take these 2 things, pre-litigation mediation and the use of technology being appropriate for mediation, then I see now a post-COVID picture of mediation which is much larger than what one would have seen 6 months back.
Right. So that's a very interesting observation of yours. And we now move on to the next speaker, Mr. Parvesh. Parvesh, you have been an in-house counsel for over 20 years standing. You've been involved in mediation and commercial arbitrations in India and overseas. Your thoughts on technology and resolving the justice delivery mechanism from the industry's perspective. What are your thoughts from an industry perspective?
Thanks, Kirit, and thanks for inviting me for this discussion. It's always a pleasure to hear Justice Sikri and the other panelists on board. So, Kirit, I'm very happy to hear nowadays that we are discussing on second phase of technology use in the legal domain. So till yesterday, like before COVID-19, our discussions were more concentrated on the first phase of technology, like how legal domain can use technology for the better efficiency of their output. The discussions were more on the legal professionals in a law firm and the in-house counsel. So we were discussing the concept of technology to be used by the lawyers, like using the various softwares, being the contract implementation software, contract management software, litigation management software, and the legal research, which always gives you, which always have the plus and minus of that. Like even the lawyers in our various discussion during last couple of years, even the lawyers were not habitual or ready to take that technology in their system. Like we have seen that there's a fact that we have seen the lawyers who always use, including me at some point of time, like who always try to use the books rather to research on the computer. They always like the smell of the book, and yes, anything. Even I was discussing other day with one of the lawyers. He told during the COVID-19 also he has a set printer at his place. So even if a mail he has to finalize with his junior, he has to dictate and make correction in that. So technology use was always under discussion. The first phase, second phase of technology use, like hearing through video conferencing, was much beyond in our thoughts. Like that was the second phase, which must be coming after 1 year, 2 years, or after a couple of years. So before that, if I will take my exposure, my experience of last 20 years in corporate sector, where I've seen that, like I spent around 10 years with one of the big corporates in Gurgaon. So you won't believe the cases or the arbitration I was handling with hundreds of crores of arbitration, and the low stake arbitration as well. The solution or the end result of that arbitration in last 5 years, barring 1 or 2 arbitration, I was not able to complete any of the arbitration in system, where the last amendment came that which has to complete it within 12 months or the 18 months. So you won't believe that how, like, with due respect to judiciary, with due respect to our arbitrators, but the issue is, like, there is much burden on our judiciary. We are not equipped with technology. We don't want to use technology to resolve that. Everything is so physical, and we are unable to reach to a conclusion. Being an industry person, I always need a solution for my problem. So if my arbitration is going for 5 years, like a small arbitration with few crores of rupees, I finished in 6 years. So that's not the use of our. There's not a proper justice given to the end user. So the technology which we were using was on the legal domain for the professional in the system, and on the judiciary side, the use of technology was limited to filing e-courts, which Justice Sikri and the other panelists have just mentioned. The e-courts, e-court does mean that we are reducing the paperwork. Typically, the intent was to reduce the paperwork, and the next phase probably will be to use those e-filing for research, for accessing the previous case to bring out bringing the result of a new case, like, because the settled case can be approached immediately. So that was the one technology used in the system. So like I remember in a couple of years back in 2017, in one of the forum like this where we are discussing today, we debated on a concept of online arbitration. So that was a new concept. It was in 2016-17, I do remember, where the e-commerce was on boom. So there was no thought on online arbitration at that time. So when we discussed online arbitration, there was a concept. It was a forum of around 100 in-house consuls where we were discussing. That was appreciated in a big way, that if for the small matters there is an online arbitration system, no need to approach to arbitrator, go to their place or to fix a new venue, bringing the 3 arbitrator at one place, and some of the times meetings are just adjourned because one or the 2 procedural criteria has not been met. So the online arbitration concept has been appreciated by all those, and we have prepared one concept note, though we cannot deliver it to ministry at that time, but certainly we'll like to share that ministry as well of the concept note prepared at that time. So being an industry person, what we face that our solution in the judiciary should be resolved at the earliest, right? So it should not be prolonged for long. And we generally discuss that because there is so much burden on our judiciary. So the result come in average, I was going through one data that average solution of a case is 17 years, which does mean that we generally say that the operation is successful, but the patient is dead.
That's
so
right.
The technology will certainly help to come out from those issues. I'm very happy that the technology the second phase of technology has been initiated by our Honorable Supreme Court and the High Courts of India, that the e-hearings are going on, which is certainly, though it is limited to the urgent matters, but certainly giving an idea to idea to the lawyers and the judiciary, our honorable judges, that how we can conduct the e-hearing, that no one need to travel from one place to other. I'm sitting in Chennai, I'm sitting in Delhi, I need not to travel at other place, which is reducing my cost, which is reducing my time. So the intent is that it is reducing the complete man-hour in the system. That is one. So second, being an industry person, what my expectation from the resolution process by the use of technology is that it should be convenient for me, it should be accurate, it should be it should save my time, it should be less expensive, and the lower manual hours should be there.
Right.
So these points are certainly helping us. And coming to the last slide, coming to this point of coming to the COVID-19. So I will treat that COVID-19 as a blessing in disguise, because with this COVID-19 that has make us familiar with the technology, the Zoom meetings, the Microsoft Team meetings. 4 months back, it was a technology concept for the person who are into IT domain. Lawyers were not used to these online meetings. Now everyone is doing that. So I compliment our system of judiciary adopting this practice, and happy that we are getting familiar with this system, and that is helping us to easily resolve our dispute in the system.
Thanks, Pravesh. That's a very interesting observation. Now, I'll move on to the next topic of the global experience. And from the UK's new SME reform system. Mark, coming on to you, Mark, welcome this evening, and it's a pleasure to have you on the panel. You've had a very varied and rich career so far, and you've been a practitioner in the past, and now you're more into legal technology as an entrepreneur, and you're the chairman of the Metis Institute, and you have been instrumental in setting up the DIFC court in Dubai. Could you share your experiences of the global reforms that are taking place with reference to digital justice within judicial frameworks worldwide?
I certainly will, and good evening to everybody. It's a pleasure to be on this panel, a judge and other fabulous luminaries from India. And India, as you may know already, is close to my heart. I've whitewater rafted to Rishikesh. I have eaten oysters in the mangroves of the south. I've dined in the Nizam of Hyderabad's palace, because when I was regional counsel for South Asia, Middle East and Africa, India was our most, and probably remains our most, exciting market. If there's any country that can lead the way in improving access to justice, in improving lives through technology, it's India. And as we have luminaries here on the Zoom call from India, I'd like to give a shout out, if I may, to another Indian luminary, but the chairman of the Civil Court Users Association in the United Kingdom, who is also a great advocate for reform, Amir Ali, who I'm giving a wave to there, who I know is in the audience. And what I want to talk about is the difference between many of these initiatives that have been discussed, which I call automation. Sending an SMS to a lawyer is automation of an inefficient process. E-filing is automation of an inefficient process. However, I think what the courts need to embrace, and what many courts are embracing, is transformation. And that starts at the process and looks at how technology can transform justice. And I want to give some data which you might find useful. Artificial intelligence can review contracts with greater accuracy and speed than lawyers. Fact. Artificial intelligence can predict judicial outcomes with greater accuracy than QCs, Supreme Councils, and other judges. Fact. Artificial intelligence can predict with 41% greater accuracy how a criminal defendant will respond if given bail. Fact. These are transformative uses of artificial intelligence, and without scaring Judge Sikri, we now have artificial intelligence which works with judges to write the judgment for them. That's where technology is. This isn't SMSs to lawyers. This is transformative. And what does that mean? Well, let's understand the context. I work with the United Nations on the Development Goal 16.3, equal access to justice for everybody in the world. We did a huge survey around the world, including India. 40,000 people were surveyed. When asked if you had a legal problem, would you use your state courts? Would you use your court system to help resolve it? And remember, for most people, a serious legal issue is employment, landlord, tenant, land, neighbors, simple things, family, right? People were asked if you had a serious legal issue, would you rely on the courts to solve it? Only 5% said yes. The courts serve 5% of their community at the moment. So the better question when we look at transformative justice is, how do we serve the 95%? How do we fill the justice chasm? Will it be the judiciary? Well, probably not. Not because they don't want to. In my experience worldwide, the judges are absolutely at the forefront of wanting transformation. But it's the ministries, it's the civil servants, it's the administrators who fear what efficiency means for their livelihoods that tend to get in the way. So how do we fill the gap? 95% of our world does not want to use the state institutions set up to help them. More people in this world have access to the internet than have access to justice. How do we deal with that chasm? How do we transform the way justice is delivered? Well, I think it's going to be a hybrid. I think it's going to be a mixture between the private sector, looking at innovative models. We spoke earlier about mediation. If we look at the Chinese court system, which has come from a position of enormous backlog to now being with almost no backlog, the process of mediation, using trained and skilled mediators combined with the ability of the court to execute what the parties agree, is very powerful. What we forget in human interaction is, much as lawyers like to fight, and God bless us, I'm a lawyer as well, it's our job, right? People don't. Humans don't like to fight. The adversarial process doesn't serve the average citizen. So mediation is perfect, but mediation without teeth is useless. And that's where the courts come in. And it's that ability to create an environment that people can access from their phones, that they can access at 9 o'clock at night, they can access at 2 o'clock in the morning, that they can access whether they're on a plane or whether they're at home or whether they're in the office, but one that connects into and complements the justice system. That, I think, is going to be the transformation that delivers access to justice, that fills the chasm, that helps the 95%. Thank you.
Right. Thanks, Mark. That was very interesting. Now moving on to Aniruddha. Aniruddha, you're India's member at the United Nations International Law Commission, and you will also be aware that the UN Commission on International Trade Law recognized the potential of ODR a few years ago. This led to the establishment of the working group, which developed the recently adopted technical notes on online dispute resolution. What are your thoughts and viability of ODR generally in India and worldwide? Aniruddha?
Thank you, Kirit. Thank you firstly for inviting me, also to Aditya for allowing me to be here in this set of distinguished panelists. Let me begin with a clarification. The commission that I am a part of tends to work on issues which are considered to be far more important but much less consequential, unlike the topic which you have posed. But I will try to look a bit at what UNCITRAL has done. And this goes back to what was said some time back by Mr. Beer in terms of the role of Sustainable Development Goals. And access to justice is one of the Sustainable Development Goals, because United Nations realized that it's time to move from binding obligations to soft aspirational documents. which started with the Millennium Document in 2000, and now we have the Sustainable Development Goals, of which right to access is an integral part. And in that Sustainable Development Goals, or how we can see, or the example of their actual implementation is in the form of effort of using online dispute resolution. This might sound something very alien and unthought of in India, but it is something which has been used extensively in Europe. In fact, the European Commission has been extensively promoting the use of online dispute resolution. What we mean by online dispute resolution is not just e-filing, but we are conceptualizing the entire court process in itself being conducted online. But mind you, we need to keep in mind that this won't be the classical court format of an adversarial system. Because if we look at the product, the work which came out of the working group 3 of UNCITRAL committee, which is called the technical note on online dispute resolution. The technical note is of course a non-binding instrument, but it gives some advice to states as to how they could implement these online dispute resolution systems, or what they call the online courts. And this is a very thought out technical system. And in this technical system, it's almost like a parallel to the court adjudication. And there are 3 limbs of this system. The first is negotiations, where parties are encouraged to settle their disputes between themselves. Secondly, there's a facilitated dispute resolution, where there's some neutral mediator who tries to get the dispute resolved. The third is where they try to get the disputes adjudicated. But of course, all this depends on consent of the parties. And all this is meant to happen online. But one thing is very clear, even for UNCITRAL, when they were planning this, they were not expecting these high-profile disputes to go there. Their primary target was the MSME sector, the middle and the small-scale industries. Because, for example, let's take the example of Europe. Europe is extremely integrated now. And there is somebody sitting in Luxembourg and he has bought something from France. And now he wants to pursue the seller from France. The question is, rather than he filing the proceedings in Luxembourg or going all the way to France, is just not viable. But resorting to this online dispute resolution mechanism, he can simply put in a request, see what is the reaction of the seller. The seller might be interested in giving back the money or coming to some sort of dispute resolution. If not, they can move to the next level and have some sort of concrete resolution of dispute. Of course, this keeps lawyers out of the process. Myself being a lawyer, I must say it's always at times better not to have lawyers, because we tend to complicate things, especially with these smaller disputes, which are of a smaller size, which involve small consumers, very, very similar to the consumer dispute resolution mechanism we have in India, but which is still, in a sense, physical. But ODR conceptualizes the creation of an online court and everything happening online. But what is critical in all this is the role of the ODR administrator, because ODR administrator is the one who's going to provide the platform and who's responsible to ensure that this process runs seamlessly without any obstructions. And that's where access to justice is critical. It is the role, functioning, and transparency with which that service provider, that online dispute resolution provider, is going to function. And that's where the role of regulation really comes in. I'm not sure if the government of India is thinking of anything on these lines. If it does start thinking, and I think it should, because although it's a non-binding obligation, it's a soft law suggestion, and it would really help for a country of a size of India. This has been very effective in a country like China, because it's a large country, everybody has internet access. When everybody has internet access, and it just takes typing a few lines to make a complaint and try to get the dispute resolved. Why not? Because it does empower ultimately the users of the system. It does empower the MSME, the smaller size, and the mid-size company people. And I think the core really of these non-binding principles, and that is something to be kept in mind, is fairness, transparency, due process, and accountability. So these are almost the 4 pillars. And these 4 pillars can be achieved if the ODR service provider satisfies these requirements, if he is functioning at an apt level. And that's where I think government can perform the function of a regulator to ensure that there are these ODRs. we could possibly think of a situation where we have a complete competition to courts. And I'm sure courts are not interested in indulging into anything and every dispute. The courts are already far too busy with far too many things. These smaller issues for which Mr. Beer said that a claimant, a litigant doesn't want to go to court, he can still get his concerns resolved if he follows this ODR procedure. So what is going to be important is how Government of India decides to implement it, which means that there would be more than one ODR providers, which means these ODR providers would have to have sufficient amount of credibility. They might have to be given stars depending on who's good enough. And we might even see a competition of who's better. There might be a private model, or there might be a pure public model. What we see in the Europe is a completely pure public model. It is run entirely by the EU Commission. So it could be run entirely by the Ministry of Justice to make sure that there is credibility and transparency. Of course, the private sector could be involved in its structuring and functioning. Lawyers could be involved, appropriate experts could be involved. But in my view, I think it would be really going to be game changer for those disputes which don't go to court anyway. So in a sense, we are not looking at a competition, but we are looking at trying to find ways to get access to those who are otherwise unable to access justice. And I think that could be the way forward. And government could play an extremely critical role along with everybody else in terms of ensuring that this system functions properly. So I do think there's something that the UN has done. It's a resolution of the General Assembly, and states can take it forward.
Thank you so much, Aniruddha. That was very enlightening and very important for the government to consider that. And we will have Mr. Raghavendar's view in a short while. Mark, would you also, coming back to you, would you also inform us what are the initiatives that the UK government has been taking regarding the SMEs in adopting technology to resolve disputes online? I believe some recent initiatives have been taken by the UK government in this regard.
Yep, through a body called Tech Nation, which was established and funded by the government to position the United Kingdom as the leader in technology worldwide. You know, if nothing else, it's ambitious. They have set up a division looking at legal technology, and I co-chair the element of that, which is looking at resolving disputes for the SME sector. As I'm sure it is in India, the SME sector in the United Kingdom is a critical driver of the economy. 99.9% of registered companies in the United Kingdom are small to medium enterprises. They are the accelerator, they are the job creator, and they are the most heavily impacted by COVID. What kills small business is cash flow. And what kills cash flow is people not paying their bills on time. And what encourages people not to pay their bills on time is if the courts or the system doesn't require people to honor their promises. And it has to be quick. A small business has 4 weeks to pay its landlord, 4 weeks to pay its staff, 4 weeks to pay for its electricity, monthly billing. It can't wait 6 months. So when I was in Dubai, we built a platform for disputes under 150,000 US dollars. Quite a big number, right? 150,000 US dollars. On average, we resolved 92% of cases under 150,000 US dollars in less than 4 weeks. That was the deadline. 4 weeks to pay your staff, 4 weeks to pay your bills, 4 weeks to pay your landlord. 92%. If we can do it in Dubai, it can be done in India. It can be done in the UK. It can be done and is being done in China. But I suppose the question I've got is, knowing India nowhere near as well as you do, but knowing it reasonably well, India should be at the forefront. There's no reason. It's got the talent in the lawyers. It's got the talent in the judiciary. It's got the talent in the government. It's certainly got the talent in technology. It's got the vibrancy of youth. It's got the drive of leadership. So I suppose my question is how? Well, what we did in Dubai is we realized that if we built this ourselves, we would be one white paper after one working group after another. That's the nature of government and the judiciary. It's the way it works. There's no point pretending otherwise. It's the way they're set up. It creates stability. So we went to the private sector. I went to see a guy called Brad Smith, who's the president of Microsoft in Washington, DC, rather than Washington State. That would have been a flight too far. And I said, help us give access to justice for millions of Indians, actually, who were owed money in Dubai. As you know, Dubai has a very large Indian population. Largest expatriate population in Dubai are Indians. Help us give access to millions of people who don't understand courts, who don't want to go to court, who want to write their problem down on their phone or leave a voice message, who want a WhatsApp. They don't want to process, and they don't want a cost, and they don't want administration. What they want is justice. They want to deal with it like a mediation. They want it to be warm, accommodating, and friendly. Can you help us build it? And they said yes. Well, 6 weeks later, we had it. And that's what I was talking about. 92% of cases under 150,000 US dollars resolved within 4 weeks. And let me tell you, if we can do it out of a small court in Dubai with the might and the power of India, there's absolutely no doubt in my mind that you can do it there too. It just requires a partnership, finding the right partner in the private sector with a proven track record for delivery, a proven technological expertise, a proven scalability, a proven model, and a partnership with the judiciary. Why the judiciary? I'll finish on this. Because unless the determination, the mediated determination, unless what the parties agree can be enforced, it's what I call a chocolate teapot. Very attractive in theory, but utterly useless in practice. Thank you.
Thank you, Mark. Moving on to what Mark said, Mr. Raghavendra, now that the government of India has been focusing on SMEs and the MSMEs, in the light of what Mark said, I think would it not be very feasible to set up digital courts for small and medium claims in the near future?
Yeah, it's a very interesting question. But government policy, if you look at the introduction of Commercial Court Act in 2015, included comprehensively all the sectors. Whether, the definition of the commercial dispute, if you look at the section 2, subsection 1C of the Commercial Court Act, it covers, it's very open-ended, and it covers, all major 22 kind of commercial disputes. It mentions right from the intellectual property disputes, trade secrets, and, banking, insurance. It covers, every aspect of commercial or a business dispute. So that is the policy initiative government has taken, keeping in view of the, India's interest in improving the ranking in the ease of doing business. And enforcing contract is the major one to so improve the enforcing contracts performance in India, especially in the Indian commercial courts. This has been done. And Section 3 of the Commercial Court Act provides for setting up of commercial courts in all states. But there was a problem in establishing commercial courts in Delhi and Mumbai, where World Bank methodology and assessment is being introduced, and the ranking is done based on the performance of the commercial courts functioning and the way the time is reduced for dealing with the commercial litigation. So, so at present, the average time taken as per the private sector response to them as per the World Bank methodology of assessment of Indian legal system, especially the implementation of reforms under the enforcing contract, the litigation time comes to 1445 days. So considering this, we introduced a lot of reforms, especially in 2018, and another disruptive policy initiative came. That is one pre-institution mediation, as already mentioned by Sriram Panchu ji. And the second disruptive change policy initiative was to reduce the specified value of a commercial dispute from 1 crore to 3 lakhs. So if you look at the World Bank's assessment study, they give a case study. Case study mentions about the 3 lakhs of commercial dispute involving purchase of furniture by a shop. So where does this commercial dispute go? If commercial dispute, the specified value is more than 1 crore. So in Delhi, Mumbai, the court of first instance, because of its original jurisdiction of traditional nature, the act did not, facilitate setting up of district level commercial courts in Delhi and Mumbai. So Section 3 had to be amended to introduce establishment of district courts in Delhi and Mumbai, not only Delhi and Mumbai, in Chennai, in Kolkata, in Shimla. These are the 5 courts which have original jurisdiction. So this facilitated setting up of courts. So what I understand with my experience of dealing in this subject for the 3 years, we do not need a separate commercial court or a special court to deal with the matters of SMEs or MSMEs, because district court for each 1,000 cases, a dedicated court has been set up in Delhi, for instance. In Mumbai also they have set up earlier 16, and number of cases were less, so they brought into number 4. And the Honorable High Court of Mumbai decided that as and when necessary, now they will be doing the review of number of cases vis-a-vis number of courts required, the dedicated commercial court, in the end of June. So Chief Justice and full court going to decide based on number of cases filed, the time taken for that. So time taken has to reduce now. As per the data made available to me, as per the formats we supplied under the commercial courts statistical rules, which was amended recently. And the 2020 report data, 2021 assessment is done based on the 2020 data that I have provided to the World Bank already based on their questionnaire. The average time taken for the commercial dispute is 700 odd days average in Delhi, and nearly 270 days in Mumbai. If you look at the time schedule, timelines provided in the amended CPC provisions in the schedule of the Commercial Court Act, any commercial dispute should not be taking more than a year. If it goes to pre-institution mediation, where time may take minimum 3 months, and with the extension of 2 months, not more than 5 months. Means 115 days, the case should be out. If it is a non-starter and not successful, then only it comes for the normal trial and arguments. But that also happened pre-trial conference. So the virtual court system, which has taken up recently for the traffic challan cases in Delhi, successfully implemented. The data, the virtual courts for traffic challans gives that more than 250 lakh, 2.50 lakhs, 2.5 lakh cases have been settled so far. And the kind of facilities these commercial courts are going to use. And Justice Sikri sir mentioned about already functioning of paperless courts. So recently E-Committee took a decision to make all commercial courts, not only the Delhi, Mumbai ease of doing business commercial courts. The next year, the World Bank may extend the ease of doing assessment to Kolkata and Bengaluru. But all the major commercial courts, there should be, the courts should be functioning as paperless courts. So that is the main decision will be implemented. And then video conferencing facility will be there, and then virtual hearings will be there, and then fee filing recently, Supreme Court has demonstrated, Honorable Justice Bobde, Chief Justice of India, and Honorable Justice Chandrachud, they demonstrated this. And my friend and judicial officer, Ashwant Goswami, is a technocrat judge. He has a degree in engineering. He has been doing a lot of, entire e-committee team has a very technical experts. Recently, they have taken outside expert also come to know to work more. And then in phase 2, they are going to introduce, that's what I come to know, that artificial intelligence, cloud computing, data analysis, all these disruptive cutting edge technology tools will be used to analyzing already available data in the National Judicial Data Grid.
I don't mean to interrupt, but look,
Go ahead,
you've got 1.5 billion citizens, a large proportion of the world. And at this time, they need help. Maybe some people on this call can wait 5 months to get paid, 6 months, maybe that's acceptable. But in most of the countries I work with, people can't wait 5 months. That's not acceptable. That's not justice. They can't feed their families, hoping that they get justice in 5 months. We're talking, what I hear you talk about is impressive. Ease of doing business in the World Bank, creating new courts, but we're talking about adding layers of bureaucracy. We're talking about ticking boxes. We're not talking about serving people. Walk out into the street, stand 2 meters from the average citizen and say, are you impressed with our World Bank ease of doing business scores on enforcement of a hotel insolvency contract? And they say, no, I want to feed my family. And that's what justice is about. Justice serves the community, not the other way around. For so long, judiciaries have been the tail wagging the dog, and it won't last. They serve 5% of their community today. That 95% has to be filled. If it isn't filled by the judiciary, it will be filled elsewhere. It will be disintermediated. And that's not right. Private sector dispute resolution without the benefit of the state is nowhere near as effective as a combination. Public justice, open justice, published decisions, consistency, integrity, precedent. This is what the system offers. Ease of doing business. I know I've done it. I've done ease of doing business. I've ticked the boxes. Saudi Arabia is the 13th most successful judiciary in the world under the ease of doing business score. Really?
You see, if I may interject at this time, it's a very lively debate which Mr. Mark has started. You see, what Mr. Raghavendra was saying is correct insofar as the legal regime is concerned. The provision which is introduced in our legislation, the Commercial Court Act, that up to 3 lakhs, the amount of that is 300,000, how they should be settled. And of course, it talks of pre-litigation mediation, no doubt about it. And if that mediation fails, only then the case can be filed. And what Mr. Raghavendran is saying is that, okay, that the record of the performance of the commercial court so far has been satisfactory, if not exemplary, that it is taking 5 months or 7 months, etc. But what I feel is that Mr. Mark, you and Raghavendra were not on the same page. What he says is a system, no doubt about it. But what you emphasized and what Dr. Aniruddha emphasized was the process by which all this, the system is there, the legal provision is there, all this can be speeded up. And that is more important. And therefore, I feel, and there I differ with Mr. Raghavendra, and I say that there's a need to have this process in the form of what you said about intelligence, what Dr. Aniruddha said about ODR, and that how these processes can facilitate, and particularly the Dubai example of $150,000 spending. And what you said was there were different types of cases. Apart from the cases, commercial courts and commercial, those cases are these cases where the lands are not, landlords are not paid their rents, etc., or somebody has sold the goods for that, that shopkeeper has not been paid. So we have those kinds of categories of cases as well. So why not, even if those cases come within the purview of the commercial court, but then they can be segregated, as it was told, the hybrid system. And why not we segregate and pinpoint that these are the cases which, as you rightly said, don't even we can't even wait for 5 or 6 months. But then these are the cases which anyway can be settled within 4 weeks or 5 weeks. So why not bring them on that platform? Why not at that stage have this the use of artificial intelligence, and combining with the ODR, which Dr. Aniruddha said. So this is a very good suggestion which can be implemented and which can be adopted in this system, same system. And of course, what Raghavendra said is very correct. But at the same time, as it is said, and Indians, we feel it, that light comes from all, wherever it is possible. Why the sunlight is good. So here the sunlight is shown by you and sunlight is shown by Dr. Aniruddha. So why not these system be, and there can be an experiment with that. And so therefore, and the second thing which I say, that there's always a scope for improvement. Whatever we have done, maybe it is good, but then there's a scope for improvement. And this improvement can come by adopting the methodologies and the mechanism which you two have suggested. And what is the experiment, what you are saying, and that is what is important, is that 95 this nature of the persons which are of very small nature, but at the same time they remain in the system. And let me see this same thing from another angle. Now suppose these 95% cases are taken away, they are earmarked, categorized and taken away. Even the competence and the efficiency of the commercial court would increase by taking up only those 5% cases which need more attention.
That's
so
right.
that is another aspect which has to be kept into. And while doing this, why not those cases, then we say there's no harm, Mr. Raghavendra, in today's world, particularly what COVID has taught us, that why not we have some types of cases to be settled through the mechanism of ODR, which can be court cases also, which can be mediation as well, which even Mr. Sriram Panchu mentioned. So there has to be a hybrid system. I think we have to combine all the aspects together and bring out some product, much more efficient than what it is today. Why not that kind of improvement?
That's right.
That is what is needed. That is what I feel.
Yeah, thank you, sir. Thank you for your intervention and clarifying it. I just take 2 minutes. When Section 12A was introduced while amending the Commercial Court Act in 2018, same idea was there. When Section 12A was introduced, it is in the Commercial Court Act, that is the pre-institution mediation. So that has been made mandatory so that a kind of hybrid system in the commercial court introduced, and that is extended to SMEs and MSMEs. That's what I was meaning to say. But one main human right angle has been given: introduction of technology and access to justice, which Mr. Mark was mentioning and Aniruddha was mentioning, and you were also saying. That is the most disruptive scheme government has introduced, the tele-law scheme. So tele-law scheme provides access to justice to the poor and needy and marginalized people who are below the poverty line. So there is a common service center in the village level entrepreneurs set up there. There, a paralegal volunteer of the Legal Service Authority take these marginalized people to there. Through telephone and video conferencing,
totally
that access is being, advice is being given, sir.
That is legal services providing them to the poorest person or those who are
so tele-law is working there.
Approach. That's a different dimension. That is, we are not discussing that aspect here.
May I just now bring Mr. Panchu? Mr. Panchu, you'd like to make a point. May I have your views on the ongoing debate?
What Justice Sikri said, that in the commercial court litigation system, let us think of it as having the more complex cases. I think what Mark is talking about is a large volume of cases. Perhaps it could involve any complexity, which is simply a question of money due and money not paid. And my suggestion there is, why don't we use predictive artificial intelligence? You feed this case through that system of AI, and it throws out a result saying, well, this case, plaintiff would certainly win. If the defendant then, in spite of being aware of this artificial intelligence...
Mr. Panchu, you're not audible. Can you be a little louder?
Yes. So I'm focusing on the kind of cases which I think Mark is talking about, which is a large volume, low complexity, and it gets delayed to predictive artificial intelligence. Okay. Can you hear me? Whatever. My suggestion is use predictive artificial intelligence, apply it to that case, and let the defendant, the other side, know that, look, this is the result of this artificial intelligence analysis. You will certainly have to pay 95%. If the defendant then still doesn't pay, then subject him to costs and to penal rate of interest.
I think this is like early neutral evaluation, if we say so. E&E. Yeah. Yes.
On the defensive. Yes. If he still doesn't accept this, fine. But then he will pay costs and heavy rate of interest. I think if you use that, the system of making the pocket pinch, you will then get better compliance without having to go.
Yeah. I have already suggested to the government at some other forum. I think they are looking into it. How to incentivize and disincentivize as far as mediation is concerned.
Right.
Yeah.
Aniruddha, would you like to have a last word on this topic?
Well, when a judge has spoken, nobody else should be speaking after him, ideally. But since we are in a social setting, I'll just make a quick comment. I myself belong to an institution, and we tend to get defensive about our institution when anybody asks anything about the institution, whether it's right or wrong. I think what the government has achieved is extremely impressive. And the idea is not to discredit it. But I think the point what Mr. Beer was trying to make, and there's a lesson for everybody, and especially not just in the government, but even for the judiciary, is what we need a new thinking. We can, of course, throw data. We can, of course, throw provisions. We all know how Rule 711 can disrupt all proceedings before, however well planned they are. So we lawyers know how to destroy what is best created. But the point is, it's a constant battle. And it's a constant battle for a policymaker like Mr. Raghavendra. And it's a constant battle for somebody who's on interpretation of the law and from the judiciary like Justice Sikri. That how do you innovatively keep coming up with these solutions? And a good example, I think at times China has got a really bad reputation today, but that's something we need to look at. The way in which China has implemented its online dispute resolution system. Well, it's an authoritarian regime, there's no democracy, there's no discussion, that's all said and done. But the bottom line is they've managed to draw out a lot of the smaller disputes. Of course, the definition of commercial is broad, but it includes MSME as well. And
Sorry, Mr. Aniruddha, I'm interjecting. I had in 2018, there was one conference, SCO conference, where I had gone, represented the Chief Justice in that conference. And I saw the way they were doing this ODR and with the help of AI, which Mark also mentioned. And I have myself seen it. It is really amazing. You're very right. Sorry, continue.
No, not at all. No, I think that's the precise point, and that's where we can start absorbing from others. There's no harm in taking lessons from others. I think that's one thing, and we need to get a bit out of our dogmatic thinking. Of course, you have the commercial court. They're extremely efficient. They're working very well. 1 year is unimaginable in a country where it takes 40, 50 years. When I was practicing in the Supreme Court, I was involved in a dispute which went on from Aurangzeb's time property. So I've even done a 300-year-old dispute, 500-year-old dispute. But that's not our pride. And when Mr. Beer is referring to India, he's referring to in a sense of competition with China. He wants us to lead. And he wants us to lead in every sense. And therefore, when I say that there are areas, for example, an MSME can't wait for 1 year. They're going to bleed. But if we can think of a forum, and I'm very sure that, you know, innovators like Mr. Raghavendra, his team can involve other experts, can involve Justice Sikri, think of new ideas, even Mr. Beer, get his help to try to think how innovatively we can take out the smaller chunk of disputes, which takes so much of the cost and so much of the energy. For example, Mr. Beer can say here in the UK, you know, after the new rules of procedure, CPR, civil procedure rules, the court is going to ask, is the step proportionate to the cost? And is it proportionate to other proceedings? Which in my view is a big impediment in access to justice. We need not go that path, but we can find ways to ensure that there is access to justice. People need not go to court, or if they really need to go to court, it's an online system for those smaller disputes or for MSME disputes, which can be more efficient. Thank you.
I'd just like to ask a question to the panel. In terms of tribunals, we haven't been very successful in India on tribunals. Don't you think that the tribunals could be reformed and experimented with the ODR system? Of course, some of the better ones like Competition Commission is a very specialized subject, and Telecom Dispute Tribunal. But the other ones, I think this is an important time to experiment reforming the tribunals and using them as ODR platforms. Justice Sikri, would you like to answer on this one?
Yeah. You see, Kirit, I would say that it is needed. Like during COVID, if NCLT is functioning and Competition Commission, etc., they are functioning only on the basis of now video conferencing. So they have also to adopt the technology. And I will rather go to the extent of saying even Competition Commission or TDSAT.
Yes.
Of course, they are dealing with the cases which may be very complex and I mean cases with large magnitude. At the same time, from my experience, I'm saying even before Competition Commission and TDSAT, there are many cases, number of cases which are which are simple in nature and the stakes are not high, and they can also be categorized in this category where the technology can be used, and they can be decided on the basis of ODR system. And apart from that, the other tribunals like consumer courts.
Yes.
Now consumer disputes, in any case, I remember the institution like National Law School Bangalore have started mediation, ODR mediation, insofar as consumer disputes are concerned, and particularly the consumer disputes where today online sales purchases are there. And if I have some complaint, which may be, I'll say I ordered some product on online and it is not, it is defective, and I want to replace it and they are not replacing it. For such a dispute, I need not go to the court and file the case in the court. As Mark was mentioning about these kind of disputes, when I said that all these can be categorized. And why not decide these cases where simple complaint is filed online and either mediation takes place or adjudication takes place by the consumer court online? Why a person should be asked to come to the court, a consumer court, for such cases? And this may apply to almost all kinds of tribunals.
That's right.
So therefore, and today in India, with the tribunalization taking place at such a fast pace, where so many tribunals are created, and therefore large chunk of disputes are in with these tribunals also, where the consumer of justice are, whether they have to go to the tribunal or they have to come to the traditional courts, for them it is court. So therefore it should be implemented there as well. I entirely agree with you, Mr. Javali.
Yes, thank you, sir. Moving on to the last topic, I have a word each from all the panelists. This is a topic relating to due process, ethics, privacy, and confidentiality, and digital signatures. A wide topic, but if each of you could speak for 2 minutes and lend your thoughts on how this is going to emerge on the ODR platform, because this is something which a lot of people have been voicing concern. Mr. Panchu, would you like to lend your thoughts based on mediation proceedings and how confidentiality is secured?
Yeah, I think we have to be careful about confidentiality. because if it is on an ODR platform, the mediator is not in the room. The litigant is in the room just by himself, and you don't know what is being recorded, which is against the concept of mediation. So this is again, I think, something which the experts have to tell us, what can they do to protect confidentiality? Or is it only that we must provide some undertakings, take undertakings from people saying they will not abuse confidentiality, and provide some penalties, which is a standard, legal way of dealing with it. But I think the experts should tell us, is there anything they can suggest to protect confidentiality? I also think that, we should pay attention to the fact that, you may have people who are underprivileged, who have disputes, who may not be able to access the internet, who may not be able to know how to use it, and the system has to provide for them. Because if you don't, then you are denying access to justice. And that is a fundamental part of due process. So you have to realize that in this country, people will have difficulty accessing and using an online system, and the state has to provide a mechanism for them to come on board. Thirdly, I think online providers should have a good package to educate users. This is new for a lot of people, yes. The mediators will fairly quickly get to know, but every user, has to be educated. And I think it's up to the online people to devise that kind of package to educate users. I would also say, try and keep it simple. I've seen some online presentations, and frankly, if I find it complex, then I think the user is going to be bewildered. So I would say keep it simple. All that we want is a simple a communication from point A to point B, and at times you might want to take out people to room C, but keep it simple. Pay attention, please, to the quality quality of the video, the pictures. All too often, I've been on webinars and online, forums where you have glitches, quality is not there, and as it is, you're struggling, to put something into place which is going to be to substitute face-to-face contact. You have to pay attention to quality and to avoid technical glitches. I think these are some of the fundamentals, and I think to a large extent, we will have to look upon service providers to satisfy us on these concerns.
Thank you, Mr. Panchu. Mark, would you like to say a few words, your thoughts on this?
2 comments only. The first is to comment on the China situation, and only to say that the Court of the Internet in Hangzhou in China, which I believe Justice Sikri might have been referring to, the Court of the Internet, the first online internet court to resolve online disputes, was actually a joint venture between the Supreme People's Court and Alibaba, the world's #1 retailer. It comes back to public-private collaboration to deliver justice. That's my first point. The second point is around a simple fact, a proven fact. The poor do worse online than the rich. Online justice needs to be very careful to protect the vulnerable, to protect the mentally ill. It needs to understand that poor people don't always have reliable internet and they shouldn't be punished for it. So developing on, and this is something I've been advising a number of governments on as this fast move now into COVID, there are a number of statistical studies that show that the poor do not benefit entirely from online justice. It's still not a level playing field. There are many initiatives the government and the judiciary can put in place to help them. But on the flip side, access to some justice is better for many poor people than the position they were in before, which was access to no justice. So online justice, online mediation with careful thought to balancing the playing field is a significant improvement on the way in which the vast majority of our populations have been accessing justice in the past.
Thank you, Mr. Mark. Parvesh, could you lend your thoughts on this, please?
Yeah, certainly. Thanks, Kirit. So when we are discussing on online dispute resolution, so certainly before that, we have different kind of cases which are pending with the courts or which are filed with the different tribunals. But online dispute resolution is going to help for those cases which are not yet filed at any forum. Those like Mr. Justice Sikri suggested that if I have a complaint against one of the manufacturer who has delivered me the goods, so I am not going to any tribunal or any consumer forum to put my case forward, because I know I have to spend time and money which is more than the compensation I am getting. So my suggestion that it is certainly going to help. So because now the technology is big way being used by the individual, so certainly digital signatures are going to help that, so we can authenticate the claim. We should avoid the bogus claim on that. That is the one part, because digital signature is very like cheaper affair nowadays. With 200-300 rupees we can get a digital signature in India. Third, as we discuss the public-private partnership, so my suggestion to policymakers are that certainly with the online disputes resolution forums, we should totally privatize that, so that the private institution can resolve those issues, if not a higher amount, but a smaller amount can be resolved by them. If in any case privatization may be an issue, but we should privatize the facilitation centers for those resolutions. So individual like me, if I am a normal individual, I am not a lawyer, I can go to that facilitation and take their help to file my claim with them with my digital signature. Like the other processes of visa processing and everything has been privatized to the market player. So that will help me to access the justice. Otherwise, justice access will be difficult if in any case I have to approach my lawyer to do works for me. Yeah.
Thank you. Sikri, could you say some thoughts on this ODR process? On due process and ethics? This is Sikri?
Yeah, sorry, I couldn't hear. What are you saying?
If you could lend your thoughts on due process and ethics on the ODR process.
You see, I think this is on this. All these other speakers have touched upon it. Of course, as far as due process is concerned, we have to keep in mind that the process in ODR is such that it takes care of the principles of natural justice, etc., are followed. When the evidence is to be recorded, the witness is not tutored because it is not in physical presence. So the person is sitting at a distance and there's no coaching going on as far as that person, and the proper opportunity is given to both the parties. And there may be cases that sometimes after the hearing, and such situations have arisen in international arbitrations also. And going by COVID, after COVID, if I know it, I mean, my personal knowledge and otherwise it's in the public domain, that many arbitral institutions like LCIA, like ICC, like SIAC, all these they have come out with so many amendments to take care of COVID situation. And when the international arbitrations are to go on online basis, and if you see the protocol there which they have come out, and there's one protocol which is known as Seoul Protocol, in which all these measures are taken and provisions are made to ensure due process. I think we can take a help of, I mean, because we are talking of, if it is arbitration or if it is ODR in the sense mediation, etc., there is no problem at all. And even if it is this virtual hearing in the court system, like in Supreme Court today, if you remember when the guidelines are issued, they have said the evidence should not be recorded unless both the parties agree, because they know the pitfalls of that. If one party doesn't agree, then it can be tomorrow, the judgment can be challenged only on the ground of that due process was not followed and principle of natural justice was not followed, or the process of the recording of the evidence was flawed because of XYZ reasons. So, but technology can take care of that. This is my submission. And in a big way, like if suppose I give you the example of this examination of witnesses only. Today we have the technology where there can be 360 cameras, 360-degree camera, which can see whether no person is around that witness. And I have seen, because I do not know much about this DRO technology, which I have known a little about it, but some other persons have also come out with this kinds of, where they give you virtual courtrooms or virtual arbitration rooms, Now, in virtual arbitration rooms, and which may be very helpful even for mediation as well, that you are holding the sitting in a particular room, which is a virtual room where parties are also, everybody is there, but then the technology permits you to segregate. You suppose in Mr. Sriram Panchu, you want, I think you also mentioned that you want a private hearing with one of the parties, a caucus session. Then you can branch out and go to the other virtual room, which technology provides. So therefore, and then you can have such sessions with different parties separately. Likewise, in arbitration or in court hearings also, the two judges they want to discuss, or three judges on bench, or three arbitrators they want to discuss, they can shift to the other room virtually. And then, so therefore, technology can take care of all. I will only say at the end that, look, in India, insofar as data protection law is concerned, when we talk of ethics and other things as well, and all the other aspects which you raised, data protection bill has been introduced. It is with the standing committee. Standing committee has invited the objections, etc., or the comments, so that the bill can be fine-tuned and again can be presented in the parliament for passing it. Now, this had happened pre-COVID times. Now, COVID times have taught us so many things. Now, therefore, they can be appropriate provisions contained now incorporated in the data protection bill itself, so that they take care of all these aspects. That is what I say at the end.
Right. Thank you, sir. Aniruddha, one last word I'd like to have before I finish off with Mr. Raghavendra. You specialize in public international law, and there's also been talk of mediation in BITS treaty matters and ICSID. How do you see that panning out on the ODR platform? Is that feasibility?
Two aspects of your question. One is of mediation, and secondly of online dispute resolution in relation to these disputes. I was speaking at the annual session of Asia Africa Legal Consultative Organization last year on potential prospects for mediating investment disputes. ICSID has been trying to amend its rules and has been introducing some provisions on that. They're still working on it. There have been some efforts in the CETA, for example. The European Union has been pushing for mediation, although not binding, not compulsory, but voluntary. China has been trying to introduce those provisions in its investment treaties. But when we try to look at it from the perspective of online dispute resolution, the prospects of it are highly doubtful, because investment disputes are fundamentally very politicized. It's an investor, it's a host state. There are several policy considerations for a state, whether to participate, not to participate. And I must confess, I was, although very conservative about the use of mediation in investment arbitration. I remember some legal advisors of some Asian and African countries walking up to me and saying, we are really skeptical about mediation in investment disputes.
But
although they might say a lot of...
introduced.
Sorry?
Now I think ICSID has compulsorily introduced the element of mediation.
No, they cannot actually, because it's for the parties to decide. So ICSID is amending its own rules to say if under your BIT you decide to have it, then we'll facilitate it, not otherwise. Okay. Which is actually a consequence of CETA, because Canada-EU Free Trade Agreement has been the big driver of this mediation. But I do feel as time passes by, Justice Sikri said that the time is not far when investment treaties would say, because they normally have a cooling of 6 months negotiation period.
Yeah.
So they would say, rather than the 6 months negotiation, you go for compulsory mediation, doesn't matter. But I'll tell you one very interesting example. I won't quote the country, but the legal advisor came up to me and said, but yes, but for us, the question is, how much do we disclose in mediation? So government is going to be always concerned as to how much document should I bring, or even an investor would be concerned, how much document should I bring at mediation, because I might want to save it for the final day. So I think we also have to look at the whole context and how it's going to function in a certain situation. But I think I'll also touch quickly upon this whole online dispute resolution when it comes to investment arbitration. Some of the hearings are going online, but most of these hearings are not the substantive hearings in nature. For example, bifurcation proceedings, whether to bifurcate the proceedings into jurisdictional and merit stage, which is not such a highly contested issue. But when it comes to these investment disputes, because there's so many facts, and of course, at times you might even have a head of state testifying as a witness, it is helpful to have him in the room to look at the demeanor. An investor may want to get the head of state just to bring pressure on. So it's not that online dispute resolution would be the resolution in all these situations, but it can be helpful to resolve the minor disputes or those disputes which are not highly factually contested. And as Justice Sikri, I think, was very right in terms of taking evidence. So for example, having an expert evidence could be done online. So some aspects of the trial could go online, but my gut feeling is the arbitrators and the practitioners want to be on the field and not to be online for a very long time. It's just the nature of the dispute, the gravity, and then the consequences. Because some of these are confidential. The investor would not want the figures to go out in public. Some of them are actually redacted at times. So that doesn't make online dispute resolution comfortable for these large scale investment disputes or even for large commercial disputes. And the last point really is of the ability of states. A lot of these states who defend these investment disputes are smaller developing states. They don't have the technology. They're probably struggling even to pay the lawyers that they have engaged. So it's fine for a large investor, multinational corporation to afford the technology, but technology is a challenge for some of these states. And my feeling about some of the disputes in which I have been involved is states have been saying, we don't want to go on with online dispute resolution. So let's wait for the situation to settle and then we'll have the hearing. So we do have that situation. And I think it really depends on adapting the principles to the context in which we are in. Thank you.
Mark, I'm informed Mark has to leave. Mark, one final word before we close with Mr. Raghavendar.
Can you hear me now?
Yes.
But it's only to say it's been a huge pleasure. I wish I was there in India with you. I love the country. I love the ambition. I love the opportunity. And I very much have enjoyed the conversation today. So thank you very much indeed. I'm sorry, I'm on another Zoom conference now. So I'm going to love you and leave you. Have a wonderful evening. And it's been a pleasure to connect.
Thanks for loving India, Mark.
Thank you so much, Mark. It was a pleasure.
Number one, guys. Number one.
Thank you. Mr. Raghavendar, your final thoughts before we wrap up?
Could you unmute yourself, Mr. Raghavendra?
Yeah, I would like to say that technology is being leveraged in all aspects of judiciary, and government and judiciary are working both hand in hand. And the main focus is to improve the conditions of access to justice and in all levels of society it should reach. And that is the main the motto of the e-courts project, which is being spread out everywhere in all court system, whether it is district and subordinate judiciary or high courts. And Supreme Court is leading this great initiative. Yeah, thank you.
Thank you so much, everybody. I think it's been a great discussion on this webinar and a very important subject. Thank you, Justice Sikri, for sharing your thoughts and taking the time out. Thank you, Mr. Sriram Panchu.
My pleasure.
Thank you so much. It was very nice hearing your aspects on mediation and how we develop this further. Thank you. Thank you so much all the way from Luxembourg. It was a pleasure hearing your views on ODR and how things could work out in India going in the long run. Parvesh, you gave a very good insight from what the industry really wants, and hope Mr. Raghavendra and all policy makers hear your wish list and it's implemented. And last but not least, Aditya, thank you for organizing this, and I think we'll all have a lot to contribute going in the future. Thank you so much, everybody. Have a good evening.
Thank you. Goodbye. Thank you. Bye-bye.
Bye-bye.
Stay safe and take care, all of you. Thank you.
Thank you. Bye-bye.